Okay, so we have about a third of our anticipated guests, and it is exactly 10 o'clock. So let's get started. Shanti, tell us a little bit about Trek It Right and how we all got here to our presentation today.
Hi, everybody. How are you guys? I hope you guys are doing well given all the circumstances going on. I am Shanti Hoffman, co-owner of Hoffman Transportation. We have a trucking company based in Los Angeles, and we also have a course called Truck It Right where we teach you how to start or get into the trucking business. So I see a lot of my students in here. Welcome, welcome. And this is an amazing opportunity that Jennifer Grady and Anthony Mass, they do this. They're business attorneys and they help solve the truck driver shortage through legal immigration. So it's amazing that you guys are in here and you guys are going to get a lot of goodies. So I will hand the mic over to Jennifer and Anthony so they can explain a little bit about themselves.
Well, thank you, Shanti. It's such a pleasure to be here. We are putting on this webinar because I wrote a blog about this exact topic and using the EB3 to get a green card to sponsor drivers, and that's my top rated, most viewed blog, and I have a lot of drivers from around the world contacting me saying, I've heard about your shortage, I'm a good driver, I want to come to the US, how can I be sponsored and make that happen? So I'm so excited to be here connecting with Shanti and all of her students so that we can tell you a little bit more how this works and if it would be the right solution for you. So I'm here with Anthony Mance. He's our immigration attorney. We work with corporations and business owners around the country. We help with business contracts. We do employment law and immigration. So we're really outside counsel for business owners. So a little bit about me. I founded the firm in 2012. We're located in Southern California. I speak Spanish and do training and webinars all the time to keep my clients and my network informed about updates in the law. And so here we have Anthony. Let's hear a little bit about you.
Hello, my name is Anthony Mance. I am currently based in San Diego. I've been practicing immigration law since pretty much 2009, 2010 now. So it's been a while. There's been a lot of changes to the industry and the decade that I've been practicing. I focus on most areas of business immigration and then some family-based immigration as well. But mainly working with small businesses and medium-sized businesses to try to solve their business needs through immigration.
Fantastic. And then here we have Shanti, just told you a little bit about herself as a business owner and help with her school. So anything else you want us to let us know about your experience and your journey to being an owner?
Yeah, so when we started our business as a trucking company, my husband was actually the owner operator. He was, he wanted experience in the trucking industry, so he drove the first year because it was difficult to find a reliable driver. I think that's what a lot of us trucking company owners go through. I mean, getting the jobs is no problem, getting the truck is no problem, but if you have multiple trucks, you can't drive all of the trucks, right, as an owner. So you definitely need to have a good, reliable driver because that's what helps you make the money. And as we all know, it's difficult. So I was so glad when Brittany introduced me to Jennifer and she told me about this opportunity, which could help not only myself, but all of us. So that's that. With that, I know a lot of you already know all about me and my husband. So let's get to the...
We have a lot to talk about, so
right.
Let's get into it. And keep in mind, you can also add a question if you have in the chat feature. We will get to those in the end, and you can also email us. We have our information here. It will also be at the end of the presentation. You can add us on LinkedIn. So we're available to answer your questions today or after the presentation. And so just a quick disclaimer, here we are offering general principles, but if before you proceed, it's always best to speak with an attorney to go over the facts and circumstances specific to your situation. So we're going to talk about two options today. The first one is the H-2B, that's a temporary visa. And then we have the EB-3, which is a green card. And so that is a more permanent solution, whereas the H-2B is temporary, typically about 9 months, and it does have less investment and commitment on your end, but it is for a shorter time, whereas the green card is a permanent solution. But you do have to have some trust before doing that, because you would be sponsoring the person to get the green card actually before they arrive in the US, and so there is some trust there. So let's go ahead and get started and talk about this H-2B visa. What is it? So it's a temporary visa that permits US employers and agents to bring foreign nationals to the US for purposes of filling temporary non-agricultural jobs. And these are typically in the hotel industry. We do a lot of this for landscape contractors. So for example, in California, there is the planting season from the spring to the fall, and so companies need extra workers, and so they bring them over from April to October. We've also had clients in the ski industry where we brought over a avalanche guide, if you will, and that was for the winter season. So it really depends on the job and your need, what that might be. So in the trucking industry, perhaps you are helping with cleaning up after a fire. So that might be a temporary need that you would want to bring over drivers for that. So there's a few qualifications here. Number one is that there's not enough U.S. workers who are able, willing, qualified, and available to do the temporary work. So that's going to be the most key component, because there is a recruitment component to this, where you would have to post a job ad, and then only if you're not getting the ads from people here in the U.S., then you'd be able to proceed with the next step. Because this is an employment-based visa and it's in the H category, we have to make sure that the workers won't adversely affect the wages and working conditions of similarly employed U.S. workers. And for that purpose, we have to do a prevailing wage determination, where we'd find out what's the minimum wage that you would have to pay in your area. And so the point of that is so that we're not undercutting U.S. workers. And finally, we have to show that the need is temporary, and this is not really something that's permanent. So let's talk about the metropolitan statistical area, because this is the #1 reason why traditionally we haven't been getting into this area for truck drivers, because if you're doing over the road, you may be traveling through 48 states, and then you'd have to do a prevailing wage determination for all of those areas. So as I mentioned, the prevailing wage is where we would fill out some information about your company and submit it to the Department of Labor, and a few months later they would come back with a number that says, for example, in your area, in the Los Angeles metropolitan area, the minimum wage would be $16 or something like that. And so an MSA is a geographical region with high population density at its core and close economic ties throughout the area. So it could be something like New York City or Philadelphia, or it can be a metropolitan area like Dallas, Fort Worth, Norfolk, Virginia Beach, Riverside, San Bernardino. So when we work in Southern California, we can have different MSAs. We would have Los Angeles, we would have San Diego, Orange County, and then Riverside, San Bernardino. So if our clients had workers in all 4 of those areas, we would be doing 4 applications. So when I found out from Shanti that she does work with dump trucks, or maybe you're doing construction around LAX, or you are cleaning up after Northern California fires, I thought, well, maybe this could actually be something useful for people that aren't traveling through many MSAs. And so Anthony, tell us a little bit more about this topic and your experience in our last few cases.
Sure. So the underlying issue with the MSAs and H-2Bs is that when you're going through this process, primarily when you're applying for the prevailing wage, you have to give the Department of Labor a idea of the geographical locations that the prospective employees are going to be working in. And a prevailing wage can only be determined based on a geographical area. And generally that's going to be a MSA. Sometimes in some areas, it may be a little bit different. It may be smaller, it may be larger, but that's generally what they're going to go with. So if you are intending on having an employee work in one MSA, then it's pretty simple. You apply for a prevailing wage for that MSA. And then on the actual labor condition application, you state that this employee will be working only in this MSA. Where it becomes a little bit more challenging is if the employee is going to be traveling through different MSAs, different states, different cities within a state that are not within a single MSA. The reason that this is an issue is you would have to have multiple prevailing wages, because the Department of Labor, for specifically H-2Bs, states that you have to describe all the geographical areas where an employee is going to work. Now, if you, for instance, let's say you have a trucking business between San Diego and LA, that may be very simple because you can just apply for prevailing wages for those two places and then tell the Department of Labor that they will only be traveling in these two areas. But if it's, multiple locations in multiple states that are unknown, it makes it, virtually impossible to really use the H-2B, because you have to, in the application, actually describe all the possible work site locations. And for H-2Bs, the Department of Labor has said a work site location is any place where work is being performed. So for a truck driver, theoretically, that could be, the place they start out in the morning, all the places they deliver to, even if they stop to pump gas, at a gas station in the middle of a run, that could be considered a work site location. So it becomes very challenging specifically for the H-2B for truck drivers or any other employee that's going to be working outside of a single MSA and unknown locations. So.
Sure. So if you were to go from San Diego to LA, you would do San Diego, Orange County, Los Angeles, and then you would end up paying the highest of those three. That's how that would work. Mm-hmm. Great. So the next topic is, what is the period of time that this could work? So generally, you're going to submit a labor certification, and we'll get to that in a second, and that is going to tell you the period that you're allowed to come for. So it's increments of 1 year, but typically it's been 9-month periods, like April to December or December to April. That's going to depend on your need, really. So if, for example, in the ski, it was a ski instructor and we had to file that, but their season is only open from December to April, then that's how long that the period would be. And the maximum period of stay is 3 years. And then if someone is here, you can get an extension for certain circumstances. So if they are here for 3 years, they have to go outside the US for 3 months before coming back. But there are people who come here every year, and they just keep coming back on this visa. So the other thing to keep in mind is that the person that you're bringing here has to be on the list of eligible countries. And so if we look at it, we see that China is missing and Russia is missing. So take a look here. If you have somebody particular in mind that you're thinking about, they would have to be on this list of countries. And the thing to be aware of in immigration is we have different visa types, and some of them have treaties with other countries around the world. And that may be based on various factors like how warm the relations are, or if people from that country generally overstay. There's all sorts of factors figured into it, but you're going to want to check the list in the year that you apply to see if the person you want to work with is on this list. So now we want to talk about the different types of ways that you can show that you need these workers. So remember, we said that we have to show it is for a temporary need, and there's 4 types of need. So one would be seasonal. So that would be we have a season of the year or an event, something pattern that's repeatable every year. And so this wouldn't be used to fill in for your employees on vacation, but you would say, maybe I have a hotel and we have extra need in the summer, or maybe I'm a ski resort and I have extra need in the winter, or maybe if you have truckers and you know there's fire cleanup from September to December, maybe that would be the area in which you have the temporary needs. So we can go by the season, we can go by a peak load where we have a short-term demand, we can have an intermittent need, or it can be a one-time occurrence. So say for some reason, due to COVID, there is a shortage of truck drivers and now we are driving more because individuals aren't going out as much themselves. That sounds like a one-time occurrence. This is certainly unprecedented and a novel situation. And so the way that this plays out is when we do the application, we have to create what's called a statement of temporary need, and that is where we would show it's a persuasive case. And so that's where we're going to describe your company, its background, and then your contracts. And then we would say that you're unable to fill your contracts or grow your business, or you might have to shrink your business because you don't have enough drivers to work for you. So then another thing to keep in mind is that this is a very popular visa type, and so we have seen a lottery for the more popular spring to fall months. And keep in mind, landscape contracting is a big piece of this puzzle, and so a lot of people in that industry are going to be working in the summer. So when we did our winter-based applications, we were able to apply around September, October, and the person was approved in November, and the application visas didn't fill up until December. So that's really great for anybody who's thinking about a fall to spring period of time. And so the reason that this is an issue is that there's only 66,000 visas available per fiscal year, and the fiscal year in immigration starts on October 1st. And so they really split this into 2 seasons of 6 months, and there's only 33,000 for each portion. And so for the summer months, last year there were about 90,000 people applying for 33,000 spots. And so that is how they get into a lottery situation. And that is where we would apply online through a portal and then wait a little period of time, and then they would let you know if you can proceed to the next step. So if this is something you're thinking about and you do have a greater need in the October to April period of time, it's a much higher likelihood of getting approved. So then after we get all this started, we want to begin the recruitment process. And so if you need a lot of drivers or a lot of workers, this could be a little bit more time consuming. For example, with landscape contractors, a lot of people go abroad to Mexico or Central America, and they recruit there in person, and they come up with 50 to 100 workers, and then you have to process all that paperwork. If you're looking for 1, 2, or 5 drivers, this process might be a little bit easier. Perhaps you have family members or a friend or someone who's contacted you directly, or you have a relationship with someone from abroad that you'd like to bring here. I think that's probably the most common way, or you can perhaps work with a recruiter. And so once you find the person, you're going to want to vet them. You're going to want to make sure, do they speak English? Can they read English? Because obviously they're driving. Can they take their driver's test and pass right away? Can they meet the health exam requirements? So these are all things that you would want to have dealt with ahead of time. And then you may want to have an agreement with them. Since you are taking the risk of sponsoring them for their visa, you would maybe want to have an agreement about what would happen if they were to leave in a certain period of time where they have to pay back any of the fees. So Anthony, what other things have you seen in the recruiting process that you'd like to share?
I think one of the main things to keep in mind is especially when it comes to recruitment in Mexico for seasonal work, there's a lot of recruitment companies and recruiters that have popped up that, kind of hold themselves out as helping U.S. workers recruit people. And this is perfectly permissible to do as part of the H-2B process, but what employers should understand is that any recruitment relationship they create as part of this process has to be disclosed in detail to the Department of Labor and also the United States Citizenship and Immigration Services. So you want to be careful who you're working with, and you want to vet the recruiter too to make sure that what they're doing is legitimate, because what the government is looking out for is less than reputable recruiters that actually make people pay them to be picked as a potential applicant, which isn't permissible. So, a potential H-1B employee really can't pay a recruiter to get them, a slot in the recruitment process. So it has to be more above board. Everything has to be legitimate. And, if you are using a recruiter and you disclose that in the application, it's possible or likely that the Department of Labor will look into that recruiter to make sure that there aren't any red flags. So, and if you are using a recruiter that isn't reputable, if there was any kind of illegality in terms of recruiting that, can seriously harm your chances of both getting this H-2B and also being able to use the process in the future. So it's definitely something to consider when going through the process.
And what kind of assertions would the employer have to make when they're filling out the application about their relationship with the recruiter?
First, whether or not they used a recruiter, who the recruiter was, and if any money was paid to recruiters, and then if the recruiters, charged any money from the applicants to go through the process. So that's all stuff that you have to disclose, and anything that's disclosed on the application forms is the employer making a legal attestation. So, it is, under penalty of law, any statements that are made. So it has to be truthful.
And I have had people contact me and say, oh, well, I'm paying for the recruiter fee. And so that would not be the right way to do it. And the reason for that is because then, again, that's unfair competition. That's undercutting American workers by having people from abroad pay to come here, and that's really what they're trying to avoid. And Anthony, who will be paying the fees throughout the immigration process and transportation? And we'll get into this more in detail later.
This will all be the employer that is responsible for paying all fees associated with the H-2B process. So that's going to be fees associated with the application forms, fees associated with transporting the H-2B workers, and fees associated with any kind of legal services that are provided.
Okay, and then a little bit more on the recruiters. If there are people in the audience today that have worked with the recruiter and there's one you've had success with, or you think that it might be good to share with the community. I know I'm also looking to meet with recruiters because I have a lot of people contacting me to find a job, and as an attorney I'm looking to develop that relationship either with employers who are looking or with the recruiter. So if there is one you have and you want to add it in the chat for the community to read, that would be great. And then just a reminder, you can continue to add your questions in the chat as we go. And so the time that you're going to have them, the way that this works, it's multiple steps. We have first the prevailing wage, then a few months later the labor condition application, then a few months later the application with the USCIS, and then once you get that approval, then we move into consular processing, which is because the person is already abroad, they have to go to the consulate or the embassy in their home country and have an interview. So you're going to want to have all of this ready to go by that point in time. So the next step is to get the prevailing wage determination. And this is what we mentioned earlier, where if we have drivers going through multiple places, you'd have to get a prevailing wage for each metropolitan statistical area. And so you would do this at least 60 days before filing a labor certification. So the way this works is, say your target start date was April 1st. The first day that you can apply for the labor condition application is January 1st. So then that would put us 60 days before that. So around November 1st, you would calculate the days each year, and that is when you would file this. And it's a form, it's about 5 pages, it's not too complicated, and then you get that back, and that's going to give you the wage rate. So then the important part that we start working on earlier in the application process is the statement of temporary need. And so this is where you're going to tell the Department of Labor why you need these workers and why you're unable to find American workers. And so there are certain industries that we've seen where Americans don't want to do them, and that is why we're able to look for workers abroad. So we are in this COVID situation where we do have a lot of unemployment, so it's yet to be seen how that will impact the recruitment process. A lot of people maybe prefer to stay on unemployment, especially in California. There's an extra $600 a week. So just because we're in unemployment doesn't mean people are actually going to be looking for the job. So that's something that we'll see how that works. So Anthony, tell us a little bit more about the statement that we work on.
So the statement of need, as you mentioned, it's a persuasive statement. It's going to generally be a few pages long, and it's going to outline the position. It's going to include a portion where you have to describe which one of the temporary needs you're actually applying for. So if it's seasonal, if it's peak load, if it's a one-time occurrence, you have to explain why your position meets the definition of one of those categories. So for instance, if you're talking about a seasonal job, you have to explain why it's reoccurring, why it occurs the same time every year, why it's temporary, and why it's not, or it's either not replacing permanent workers, or it's just being added to existing permanent labor. So that's a major portion of it. And then also you have to describe why, if you don't have this additional workload or employees, basically why it's going to be harmful to your company. So the system has changed considerably in the past few years. It used to be that as part of the labor condition process, the employer had to submit all kinds of documentation, including employment reports, financial reports, industry reports, to prove that there actually is a need. The Department of Labor realized that was extremely detrimental to employers who needed employees in a short period of time, who may not have the resources to put that stuff together. So essentially what they did is they decided that it was better to kind of take employers at their word. So they changed it and now just require a detailed statement explaining everything. And then later on, if they decide they want to audit the employer and they want to see those records, they can do that, but they don't require it as part of the application. So that has made it very important that the statement is very clear and concise why there is a need and why that need fits into one of the specific categories for the H-2B. And obviously, if it's an industry that is, it's well known that it's seasonal, for instance, landscaping, then it makes it a little easier. For the trucking industry, it may be a little bit more challenging because the officer who's reviewing it may not be as familiar with that industry. So it makes it all the more important to make it very clear and concise what you're trying to get across.
There are well-documented reports by trucking associations that I used even in preparing this presentation today. So I think trucking industry is something that is well known. You can find some reports, you can attach them, you can reference them. I would recommend that as well. All right, so then the next step is the labor certification. And so this is where you would file this with the state workforce agency. So that's going to be in the state of your headquarters or where the person would be working. And you'll file that 75 to 90 calendar days before the proposed employment start date. So as you can see, there's a lot of deadlines here. If you decide to move forward with this, we would speak with you about it, and then we would calendar out all of the things that you'd have to do. So if you were looking at that fall or winter start period, this is the perfect time right now, because we would really ramp up what we're doing starting in the summer. And so you would file also the labor certification with the Department of Labor. That's something we do online in a portal. And then we'd include that statement of temporary needs. So there's a few things that we would do in the past years. We've been there on New Year's Eve, at 9 p.m. Pacific, which is midnight Eastern time, trying to get these in and be the first one in for the popular season. And so then if you are get a you get the approval, tentative approval, then you would get instructions on how to do the recruitment. And so that is the next thing that we'll talk about.
One thing I would add to the labor certification application, going back to what we were describing earlier about a situation where you may have a H-2B worker working in multiple MSAs. For instance, in our example, a driver driving from San Diego to LA. What you would have to do is you have to file two or maybe even three prevailing wage determination applications, simply because they would be traveling through San Diego County, Orange County, and LA County. And then also, because you had three separate labor condition applications, you would be required to file three separate labor certification applications with the Department of Labor. It's it is very, unfortunately, it's very time consuming and work consuming to do this, but unfortunately that's the way that the Department of Labor has the system set up right now. You may be able to limit it to two if you can show that you're within a certain area geographically, but it will most likely, if you have multiple prevailing wages, you're going to have multiple labor condition applications for the same employee.
And you're not filing any fees for those at that time, but for each application, we're going to say based on each area, geographical MSA, you will also be filing the I-140, and that has a $460 filing fee. So just keep that in mind. So if you're only in one area, great, you only have to do this once, but if you are in a bigger region, you may have to do several applications. So once you have the go-ahead to move on to the recruitment process, that is the next step, and that can last for about 1 to 2 weeks. And you generally would post an ad in your local newspaper with the largest circulation on a weekday and 2 Sundays. And Anthony, have they agreed that we can use online yet, or we still have to do newspapers?
No, so they've changed it dramatically now. So newspapers are no longer required, and there actually has been a pushback from the newspaper industry to keep this requirement because it is a source of income for them. But the Department of Labor has decided what they're doing now is you only have to file the ad with the state workforce agency, and then the U.S. government has actually created a clearinghouse. It's basically an online job portal for people to find temporary work, and so they automatically upload it to that. So all of their recruitment process in terms of advertising with newspapers has been done away with. And so it's made the process a lot cheaper and a lot easier for employers moving forward. So this past H-2B season was the first time that they were changing the process. So there was some uncertainty and confusion on it, but ultimately what it's come down to is it's made the process a lot easier, and the employer is no longer required to do the newspapers.
And that's great, because they could be $1,000 per ad, and we would have to sit there and go back and forth and edit them down to be as concise as possible while still using all of the required words and language that we were able to use. So this will be the first period that we can do it this way, so that's great. And then we've also posted them at the job site, and we've had our clients take photos with time and date stamps to prove that they did that. So again, point here being they want to give U.S. workers the opportunity to come to, apply for these jobs. And then if they don't, then that's when you can proceed to the next step. So we want to keep records of all the applications. And so that is in case there is an audit. So we would help you figure out how to do the recruitment process. We'd help you write the job ad, tell you where we would actually help with the postings, and then we would give you a rubric of how to evaluate the candidates, because if they are minimally qualified, then you have to interview them. So Anthony, do you want to tell us a little bit about that?
Yeah, so for H-2Bs, generally the type of employees that you're going to be hiring are going to be what's considered non-professional positions, meaning that a university degree is not required. So normally it's either a situation where no prior experience or education is required, or it's very nuanced. So in the trucking industry, it may be more nuanced because you may need people that have experience driving trucks. You may need them to have certain training. So that would be part of the process. So what the most essential thing to remember is that anybody that applies for the job who's a U.S. worker, and a U.S. worker is defined as a U.S. citizen, a permanent resident, or certain special circumstances for people that are here as asylum seekers, and in a few other very rare circumstances, but generally it's going to be U.S. citizens and permanent residents. So if a U.S. citizen or permanent resident applies for the job, you can't treat them any differently than you would the proposed foreign worker. So any requirements that you put on the U.S. worker, you have to put on the foreign worker and vice versa. And so when you're going through this recruitment process, if somebody applies and they're minimally qualified, and one thing to keep in mind is this is a very different scenario than you would probably used to as an employer, because as an employer, you're going to be looking for the most qualified employees. In this case, you have to consider only the people who are also minimally qualified, because the Department of Labor says that any U.S. worker that meets the minimum requirements of the job as you posted it has to be considered. And if you can't find any reason to disqualify them, you don't have to necessarily hire them, but they will take away from one person that you're requesting for a foreign worker. So let's say that you're applying for 5 foreign workers to fill 5 roles, and let's say that you have one person, U.S. citizen or permanent resident, that applies, and they're minimally qualified, but for some reason you still don't think they can do the job. Well, you don't have to hire them, but that means you could only then have 4 slots to hire the foreign workers. So that's something to keep in mind. And, as we'll describe here moving forward, you do have to put a recruitment report together showing that you actually considered all of these applicants and came up with legitimate business-based reasons for disqualifying them.
And so what if someone doesn't fit in with your company culture? Is that a good reason?
It is not.
No.
So soft reasons, as the Department of Labor calls it, so cultural issues or just not fitting in with personality, things like that are not considered and can't be used for disqualifying. It can only be legitimate, objective, business-based reasons. For instance, let's say somebody does not have the necessary experience driving a truck, or let's say somebody is not willing to work the hours that you need them to work. Those are legitimate business-based reasons for rejecting somebody.
Sure. So there's always a push and pull that we have as the attorneys between having the job be a little bit more detailed so that you don't have anybody and everybody applying, and then not having it so detailed so that it's excluding everyone. So there is somewhat of an art to doing that. In trucking, there may not be as many things because it may be, physical requirements, licensure requirements, scheduling requirements, as opposed to other areas that might have more for certain types of jobs.
Mm-hmm.
So then the next step, so say we get the prevailing wage, then we get through and have the labor condition application certified because you've completed the recruitment. Now we have the portion where we are filing the application with USCIS, that's U.S. Citizenship and Immigration Service, and that is the body here that is managing the immigration applications. And so what we would do now is file a form, it's called I-129, and then we would include supporting evidence that's going to talk about your company. We might have corporate documents, we might have financial documents. We have to prove that you'll be able to pay the salary for this worker. And so then we would put that in an application, we'd send a cover letter in tabs, we would mail it into USCIS, and then they would give you a decision. So ordinarily, there is another feature called premium processing, and if you pay another $4,440, then you are eligible to have that reviewed in a 15 calendar days. So we have something a little bit unusual right now due to COVID with all of the closures and changes that is temporarily suspended. So we are still filing applications, but we're just having to wait longer for them to be reviewed. So we're hoping that that will be reinstituted. We know that USCIS field offices are scheduled to open June 4th. So assuming that happens, we're hoping perhaps premium processing could come back in June or July. So that's just really something that's unique to this period in time. And then you can also file the application and then mail in the form for premium processing later once that is reinstated. So basically, this is one of the, if you kind of get through the first few stages and you have a good application, then this is where we would get to this spot. There's possible they may send you a request for more evidence, and that would be requesting additional documents to support the qualifications for this visa. And so then once you get that, then we move to the last piece, which is the consular processing. And so if a person was here in the United States, they would mail in their application to USCIS. And so maybe perhaps you do have someone that you've met and they're here on a different visa type, perhaps student visa, and they're going to move to this, then we would mail it in. But if they are abroad, we have to apply through the consulate or the embassy, depending on what is available in their home country. And we would file a form online. It's called a DS-160. And Anthony, what is the fee on that?
There's no fee to file the DS-160. There will be a visa processing fee. And while it can be different at different embassies, usually it's going to be anywhere between $180 to $280. And that's per visa. So if there's a primary applicant and then their family, each person would have to pay that visa processing fee.
And then would they be reimbursed for that fee? So say they're going to pay it when they're submitting it online, would the employer reimburse them for that cost?
The employer can reimburse them for that cost. There's some question as to whether the visa fee itself falls into the employer requirement because it is actually specific and personal to the employee, whereas the H-2B process is the employer looking to reap a benefit from the employee. So, it's one of those situations where it's kind of a gray area, but it's probably best practices for the employer to pay that just to be safe. There's going to be no harm to the employer for paying that fee.
Okay, and so this is the opportunity where if someone were to bring a spouse or minor children, and minor being under the age of 21, they would fill out forms for themselves. They would come and attend the interview as well. And so they would bring their approval notice. They would bring certain documents. We would give you a list of what those are. Some are biographical. Since it's a temporary visa, we would want to include evidence to show that the person has a life and connections back in their home country and they're going to return after the visa is over. And so the point is not to have people overstay and then they're going to be out of status and cause some issues.
One point I will bring up here, and this goes back to the early recruitment, the pre-recruitment stage, and potentially working with a recruiter. They will be going for consular interviews, and part of that process is going to be the consulate checking to make sure that the applicant doesn't have a criminal record, does not have a record of violating U.S. immigration laws, or anything else that may make them inadmissible to the United States. So it behooves the employer to really, get this information early before you start the process, so you don't run into a situation where, you go through this whole process expecting to bring this person to the U.S. and then find out that they're inadmissible for some reason. So that is important to, especially when it comes to potential criminal records, whether in the U.S. or their home country or, potentially in other countries. And probably most importantly, that they haven't violated any U.S. immigration laws, because that will likely make them inadmissible, or at least make it very hard for them to get approved.
Sure. So when we're helping with the recruitment process, we would give a questionnaire for our clients to give to the people that they're working with, and that is definitely going to be on there. And there are some people that have the red flags that it's just not really worth the risk for the employer, so they're going to work with someone else who doesn't have those issues. And I would say a lot of it might be coming here before to the U.S. and then overstaying. And the issue with the overstay is if you are here without a legal status for 6 months or more, you can be banned from returning to the U.S. for 3 years. And if you overstay a year or more, you can be banned from coming back for 10 years. And so that does happen. That's just things you might want to be on alert for.
And one good thing to know about the process is when you are applying for the petition part of the process, you don't have to list the names of every applicant, provided that they come from the same country and they are going to be doing the same job. You can just say, for instance, if your labor certification application approved, let's say 10 H-2B employees, you can just put on the application 10 as of yet unspecified employees from, Mexico. And then, so for instance, if you have 10 people in mind and one of them gets rejected, you can actually replace them with somebody else after the fact that can then get that visa and fill that role, provided they meet the requirements.
And it may be easier to find someone from Mexico or Canada based on licensure issues if their license has any reciprocity. That's another thing to keep in mind. So last point on the H-2Bs is the transportation. So the employer would be responsible for bringing the person to the United States. So if we have a lot of people, for example, from Mexico, they often meet at the consulate and then have a bus and drive them to the work site. If it's an individual and they're coming from Europe, for example, obviously they'll have to fly here. So you can either have them pay for the flight and you would reimburse it within the first week if they work that first week, or you may book the flight for them themselves. And then if they do abandon the job during the period, you have to let the Department of Labor and Department of Homeland Security know within 2 days. And then you would also have them sign an agreement saying that they know if they don't show up that they're going to be terminated for cause. And so then, as we mentioned, if they're there through the first week, you'd reimburse the travel expenses. And then if they meet 50% of the work period, which is the whole visa season, then you would pay for their return home. And so then if it worked out and you want to work with them again, you would reapply again. And so I know in terms of the lottery for the popular season, sometimes they have authorized an additional 15,000 visas, and that is to returning workers. So you do want to have that relationship in case there's that opportunity there. All right, so the next one, we've talked a lot about H-2B, but some of the things that we talked about are repeatable and applicable to this as well. But the EB-3 is for unskilled workers, and in this context, unskilled means requiring less than 2 years training or experience, and it's not a temporary or seasonal nature. So say you have driving requirements and needs year-round, this might be a better option for you. Or if you are over the road and you're driving throughout the country or many areas, this might be the better option as well. So we're going to need to file a labor certification, which we talked about earlier, and then we're going to have a permanent full-time job offer. So a lot of times I mentioned that I have drivers around the world contacting me, want to do this, but until they have a job offer, nothing's going to happen. So that's going to have to be a job offer in writing, and then that's something we can help you with preparing. So step one would be the prevailing wage, and we have talked about this a little bit before. And in this case, it would be a 3 to 4 month review period. So prevailing wage has different time periods. So that is why you want to get this part out of the way as soon as possible. So say you're thinking about it and you want to get involved. It's not a lot of work to do this first step where we do the prevailing wage. So we do that, we wait 3 to 4 months to get the response, and then we move on. So it's kind of like a multi-step process. And this one, the time frame is a little bit longer. It can be about 8 to 12 months. So we're talking about this today. You're going to be anticipating next year. I really, in my business plan, have forecasted I'm going to need 3 extra drivers. So then you might want to start thinking about it here and now. The next step would be recruiting U.S. workers, and we did talk about that in detail in the last section. You're going to have to post the job notice for 10 days where the employees can see it. So if you have a break room, if you don't have an office, then maybe you would email that to them or put that on a server electronically. So any nuances or difference in recruitment in the EB3 context, Anthony?
Yeah, so it's going to be substantially different based on how the H-2B process is now. So for the recruitment for the permanent residence process, you have to file a job order with the state workforce agency, just as you did with the H-2B. However, you also do have to have 2 advertisements in a newspaper of general circulation for the area of intended employment, and those have to be print ads. One thing to keep in mind that makes this process different than the H-2B, we described, and this is complicated, and this is kind of just a general overview of it, but with the H-2B, because of Department of Labor interpretations, as we said, every site location is considered a location that must be determined when it comes to a prevailing wage, and therefore requires a prevailing wage determination and a labor condition application. They have, when it comes to permanent residents, they've actually looked at it differently, and they said the only work site location actually has to be likely the employer's headquarters. So if the employer has a headquarters in, say, LA, and the driver is going to be driving all over the country, you only likely need 1 prevailing wage determination application and one labor condition application. And so therefore, when recruiting, you would be advertising in the, if it's LA, it'd be the LA Times, or if you're San Diego Union Tribune, and then filing with the California State Workforce Association. So that process is a lot easier, and that's why this would be potentially a better option for employees that may be moving through multiple unknown MSAs. But the recruitment will be, as I said, in a newspaper, in the state workforce agency. And then if it is going to be a situation, if you're going to have over-the-road truck drivers that are going to be going throughout the country, a good extra practice may be to advertise the job in a national publication. If there's like a truckers magazine or industry publication like that, that just gives you a little bit more added protection, in case the Department of Labor pushes back, and you can show that you did your best effort to find as many able and willing U.S. workers as possible.
Great. Okay, so cost to file will be depending on if you're going to do a newspaper ad. And then the time frame, we have to do this at least 30 days prior to filing the prior permanent labor certification, but no more than 180 days prior to filing. So again, that's something that we would look into your start date and do planning and kind of count backwards and give you the right date for all of these things. And then all recruitment steps must be completed 30 days before filing the application for labor certification. Okay, so then this is where we're asking the Department of Labor for permission to hire the foreign worker in a permanent capacity, because there's not enough willing and able U.S. workers for the job. And so we would also do this online via the government portal. And once it's approved, you'll get a certified permanent labor certification, and then we would include that when we do the petition. And so that is the next step, where we mail it into USCIS. So you're going to include your certificate as one of your exhibits to that. And so again, this can take a few months to process as well. But if there were an audit, that could take additional time, or if for some reason it wasn't approved or you got extra requests, that could take longer.
And one thing to note too, unlike the H-2B, where you're actually required to provide the recruitment report to the Department of Labor as part of the process, you don't need to do that for the permanent labor certification. You only have to do that in the event of an audit. So for the initial application, it's just an online filing through the portal, and then they process it. And if they decide to audit it, then you would submit that information.
Mm-hmm. Okay, so we have just a few more minutes here to finish up what we're talking about, but if you haven't entered any questions in the chat, or if you've come up with some throughout the presentation, please feel free to enter those and we'll address them at the end. So similar to if the H-2B, we filed a form I-129, here we're going to be filing an I-140, and the difference is the I-129 is for temporary work, the I-140 is for permanent, which would lead to a green card. And so this is what we'd be mailing into USCIS. We would have to show the legitimate need, so we're going to have to, again, make this a persuasive case. We have to show that you have the ability to pay the salary of the employee. So if it's a bigger company, we can use a certification from your CFO or Chief Financial Officer. But if you're a smaller business, probably you're going to have to show some tax returns or P&Ls, different information, and nobody else is looking at it. I know sometimes people are hesitant to provide that information, but it's something that we would just include in the application to show that you can pay the salary of this person. And there is a filing fee. It's $700 for the I-140, and then if premium processing is available, that's $1,440. So if the premium processing weren't available, you can check the processing times. Of course, we would always let you know what those are, but you can check them if you Google Visa Bulletin. It's on the Department of State website, and they're always going to have that a month ahead, and then you have to know which category it is and find it, but that's a way to determine how long the processing fees would be. So again, if the employee is abroad, they're also going to go through the consular processing. Perhaps they were here on another visa, then this would be done in the United States. So we can only do it once a green card becomes available. And so sometimes that's because it's oversubscribed for certain countries. For example, China, Mexico, Philippines, India, there's a high demand. So sometimes they have a longer wait time than people from other countries. So that's another piece of the planning and another consideration that you might want to look in before you decide who to move forward with, maybe someone from a country that has less of a wait time. And so when we do this, you'd do the online questionnaire. So previously we had the DS-160 for the temporary work. It would be called the DS-260 for the permanent, and that's going to have a lot more questions. They're going to have a medical exam, and then they're going to have a visa interview to take. And so then once they are approved, the consulate will keep the passport. It could be 5 to 7 days, so also factor that into calendaring how this will all work out. And then they'll put the visa in the passport, and then when they come to the US, they will have to go through immigration and be reviewed by an officer, whether that's at the port of entry where you can drive through or in the airport. So Anthony, any other final thoughts on the interviews and consular processing?
Not too much. Just, when they go through this process, because it's permanent residence as opposed to temporary, it is going to be a higher standard in terms of reviewing the case and interviewing the applicant. So again, as I said with the H-2Bs, just vetting the people beforehand to save you any, surprises during this process is definitely going to be something you want to do.
Mm-hmm. And so if you are going to work with the recruiter, ask them how they're vetting and what they're doing, because ultimately if it's somebody you don't know, we want to do a very deep background check. If it is a family member or acquaintance or someone you have a relationship with, that may be, additional points in the favor for this process. Okay, so the cost, the immigrant visa fee is $325, and the visa center processing wait times can be a few weeks to several months depending on the workload and the background. And so they'd have to go through National Visa Center first before doing their consular interview. And so again, in terms of waiting times, traditionally at the consulates and embassies, it's been about 1 to 3 weeks, and we've encouraged our applicants who have a real need to get here quickly to keep checking back for any cancellations that can move it up. Right now, because consulates have been closed due to COVID, that could be a little bit of a backup. But again, this is something that by the time you get to this stage, it could be a year from now, so hopefully that will have cleared up. All right, so that's an overview of the process. We've compared the H-2B to the EB-3. H-2B, again, is if you're going to be, I like to call it for local truck drivers because it's going to be in only a few MSAs and it's going to be a temporary need, whereas the green card, it's a little bit more time, more of an investment, but it's something permanent. So if it's something that you do know you want this person to be here for multiple years, that might be a good opportunity. So we have 2 articles on our blog at gradyfirm.com. You can look under the resources tab and you'll see that we have an article about the EB-3 and about the H-2B, and we can send all of our attendees today links to that. And then we do have other pages of resources right now that are timely about AB5, with the independent contractor classification rule. I know that's been a big deal for truckers, and we have a COVID page as well. The areas that we practice are immigration law, employment law, business law, and we're corporate counsel to companies. So you can find us online on LinkedIn, Facebook, Instagram, or our blog, or you can email us at info@gradyfirm.com, or you can call us at 949-798-6298. So if anybody has any questions, feel free to enter them in the chat, or Shanti, if you have any that have come up throughout the presentation, feel free to let us know.
So there is a question from Sandra. Can you file H-2B visa for a roofing company? And what about EB-3 visa for helpers?
Sure. So the visas are not based on an industry. So we've done the H-2B for ski resorts. We've done them for landscape contractors. So it's really going to come down to whether you can show that temporary need and whether it fits into one of the 4 categories. And then what was your question about helpers?
She said, what about EB-3 visa for helpers?
One thing I would say about that is, so the EB-3 visa, technically, if you're talking about unskilled labor, it can be used for a lot of different areas. I mean, people do use it for domestic workers, so nannies and things like that. It has been successful for that. The biggest challenge really when it comes to a situation like that is how you can show that there's no able US workers, you know, and remember, you can't just say, well, you know, I don't like their personality, which has always been kind of a challenge for something like nannies, because personality is a big part of it, but the Department of Labor doesn't really look at it. So it would be a case-by-case basis kind of situation, but theoretically, I mean, it could work for any kind of unskilled labor.
Mm-hmm. And then we have on our website a list of all the different visa types, whether that's immigrant or non-immigrant, which would mean with the intent to become a permanent resident or just to be here temporarily. So we have them listed into categories. You can take a look there, and we can really help you with any type. We just we're kind of talking about this for truck drivers because this is where we're seeing the biggest need right now.
And also, it looks like I got another question. It may have just come to me. They were asking, is the list of countries the same for both visas? No. So H-2Bs have specific countries that can take part in the process, and that was the list that we put up. Although I did notice, I think we forgot to put Mexico on there. Mexico is definitely on the list of countries that are H-2B permissible. For the EB-3, any country is applicable. As Jennifer said, though, some countries are certainly going to be much more challenging because the Department of State only gives out so many green cards to every country per year. And if there's a lot of applicants, you know, as we've seen with China and India, the wait time could be years before a green card becomes available because people are put in a queue until a green card becomes available for them. Other countries that are, you know, very undersubscribed, you know, it may be a lot quicker you may be able to immediately get a green card available.
Okay, we have another question. Do drivers from Mexico need a US license to drive?
That is something that it's interesting. So there is a treaty between the United States and Mexico that permits transferability of licenses. Now, I would caution that you want to review the applicant's license to make sure that it fits with it. But broadly speaking, if it's North America, so you're talking about Canada or Mexico, there are treaties that allow for transferability. Other countries, there isn't that transferability.
Mm-hmm. And so I had heard from someone from Canada that said he can drive here and drives all the time. So that's really something that is a possibility, but you want to look and see what are the requirements in your state and the license that person has. And so the other thing you want to make sure is that they're going to have that license at the time that they're going to start the employment. So perhaps if they are from Eastern Europe, they're going to have to come here and then get the license before they can start working. So in the green card context, they'd already have the green card, so they can come here and they can wait a little bit, but you might want to have a contract with them that says you're going to have to get that license by a certain period of time. We don't want to have you take 6 months to get it, or you have to take an accelerated course. So just something to think about that. So another question, if we had the presentation in Spanish, we don't yet, but we can look into translating that, or at least giving you the summary or translating that blog into Spanish so that you can have the information that you need. And I do speak Spanish, so that can also help as well in the communications and working with those of you who do speak Spanish. All right, so any other questions or thoughts? If not, you've been a fantastic audience. I hope this has provided you with an overview and some clarity, and maybe taught you about something that you didn't know was available. So if you are interested in learning more, you can set up a complimentary 15-minute consultation with us. You can schedule it online at gradyfirm.com. We have a scheduling tab. You can go ahead and fill that out there. And then we also offer 30 and 60-minute calls as well if you want to get more in depth and actually speak with us to get legal advice. So I want to give a major thank you to Shanti for sharing this with her network. We'd be happy to come back in the future and talk about these topics in more detail, or we can also talk about employment law issues as well. And thank you, Anthony. You always provide amazing advice. We're happy to have you.
Thank you so much. You guys been great, and I hope this really helped everyone else out there, because it is very beneficial.
Well, great. Well, thank you so much, and we will speak with you soon.
Okay, thanks.